Good evening, ladies and gentlemen. I, Major Jayesh Varma, once again welcome you all to this platform, Value Talks, where we discussed varied topics of your interest. Today, we have with us Advocate Govind Bali, who is one of the well-known advocates, and he has been awarded Nation's Icon Award in 2022, that is last year, as well as Icons of Asia Award. He is a founder partner of Fast Track Legal Solutions, which provide offers range of legal solutions starting from criminal law, divorce law, family law, corporate law, etc., etc. So he will be giving his insights to us today regarding Real Estate Regulatory Authority, RERA Act, and we will try and find out the nuances of law which impacts your position as a buyer in terms of real estate, let it be for your personal use or as an investment. Let me also tell you that he has also been associated with major and well-known cases such as abrogation of Article 370 CA and NRC. So Govind sir, welcome to the show.
Hi, thank you, sir. Thank you.
Well, Govind sir, सीधे टॉपिक पर आते हैं. So see, generally, as a human being, we have a tendency of finding, since we, get into onto the ground where we start earning, all of us always have a dream of having own house. Now, in the market, if you see, there are types of agents and builders available. Lot of frauds happen. Taking that into consideration, this government authority or body, RERA. So we would like to know how, as a common man, I can utilize the services of the law for protection of my assets. But to know that, first, could you please throw some light on RERA, what exactly it is and how does it impacts, the home buyers and real estate agent at large?
As the old saying says, roti, kapda, and makan are the three things that the individual needs. So basically, makan here always has been a value essence to the mankind. But what used to happen in the past was there was no law regarding the builders or the people who were buying and making houses. So generally, what used to happen was the builder used to launch a project, take the money from the investors there and start investing in a new project at somewhere else. And there was no accountability of the builders as such, and there was no admissibility of the problems at large because there was no dedicated tribunal for the issues to come up. Now, since 2016, the RERA Act has come into place. So RERA basically stands for the Real Estate Act, which is basically dealing with the builders' rights of the buyers, laws that the buyers have to have in their concern, the laws that the builders would have to follow. And one needs to understand that this act is not just about the Real Estate Regulatory Authority, but it is also about the regulation and development of the buildings at large. So RERA Act basically, as I can sum it up, is a new act which has come up with a tribunal for property related matters of the properties which are RERA notified. So it is very important to understand the properties only which are RERA notified would fall under this act. Not every property would fall under RERA.
Understood. So the second part of the question that, as you said, that it is only associated with few properties. How does a buyer or how does the RERA law then applies to a buyer who's buying a property where he's not, the builder is not associated with RERA?
So now the question here comes in that all states other than the state of West Bengal generally have RERA in place. Even the RERA has been under the talks to be, come into place in West Bengal also. So generally where multinationals are there, where the cities are developing and, multi-story buildings are coming up, states have made it a point that RERA Act should be there because through RERA, even the government is earning a lot of revenue because it has streamlined the amount of taxes that the builders would be paying. It has streamlined the amount of, taxes that have to come into place. It has also streamlined the amount of money that has to be invested by a buyer has to be kept safe. Now, as far as it is concerned that how would a buyer who's not related, who's bought a property which is not part of RERA take legal action, that would be a debate in its own self because there are various ways to go about it. You can file a recovery suit, you can go for a civil suit, you can go for a writ jurisdiction case stating that your rights have been violated, your right to life has been violated because you've not been given a residence to stay at. So these are the things which have been sidelined by the RERA Act. Rather than going to the High Court or rather than going to the Supreme Court and the lower courts, the civil jurisdiction has been converted into something like a quasi-judicial body, which is adjudicating process now in the RERA Act, which has made the process bit faster. When I say it has become bit faster, is because as we all know, civil suits do not have a timeline. But generally, from my experience, I have observed that the decisions in a RERA case comes out to be in 2 to 2.5 years till the final settlement takes place. Now, how do we understand that RERA is part of our building or not, or the society or not, is a different question altogether, which I know that I'll be answering in the further talk.
Understood. Understood. Thank you very much, sir. So, further understanding the RERA now, considering that the builder is associated with RERA and as a buyer, I am proceeding with the transactions. So, what are the main rights and what are the protections offered to the home buyer under this RERA Act?
So basically, we need to understand that before this act came into place, there was no concept of what is called as the carpet area.
Understood.
So builder was building the houses and selling it on the super area or the total area of the constructed property, whereas the concept of carpet area came into existence only after the RERA Act. So first safeguard is that you have to pay only for the carpet area. You do not have to pay for the super built-up area. Second thing is that there is a escrow account which has to be made up by the builder in which more than 70% of the total amount received is kept so that the builder cannot misutilize it for any other project at hand. So that is the very catch. That is why the builders have come up with the concept of pre-launch projects. So generally pre-launch prices are comparatively low, but these prices are going into the escrow accounts in a different manner. They are not going in the same manner. Now, what happens with the escrow accounts is that these escrow accounts are the safeguarded FD of the buyer, basically. So even
Understood.
if the project fails, this escrow account would be utilized for giving back the money. This escrow account would be utilized for building the buildings. This escrow account cannot have the full withdrawal till the time the occupation certificate and the completion certificate has not been given. Now, the
Understood.
question, now another right that RERA gives us is that you can go to the courts to claim any delay in filings. You can also go to the courts for any, you know, non-acceptance or the non-fulfillment of the promises made. And you can also withdraw from the project.
Understood. So, you mean to say that in case of delay, you can approach RERA authorities for some solution? Because that is the major
Certainly,
cause of
certainly, yes.
concern. If you see, in last 10 to 15 years, there have been many and many cases, whereas it is initially delayed, then intentionally delayed, and then some kind of fraud happened where people have lost their money. So what is the delay at which one should approach RERA for solution?
So
What is the
basically,
alleged delay?
basically, when you buy a house, there is a builder-buyer agreement that comes into place.
Yes,
Now, the builder-buyer agreement is the actual place where the super built-up area is written, where the carpet area is written, where the other areas of the total property are written. There is a
understood.
tentative date given in the
Mhm.
agreement. For example, the date is that from the day of booking, it is 3 years. Okay. So
Correct.
3 years plus 6 months of other extra time given. That is the minimum amount that the builder gets to construct the property.
Understood.
Along with that, there are certain agreements because I've gone through a lot of agreements. There are certain agreements where there is a fixed rate that is written that for per day of delay, you would be getting 10 rupees per square feet, or monthly for every month of delay per square feet, you would be getting so much amount. Now, whatever the amount is XYZ, that can be enforced in the RERA tribunal and you can ask for the penalty. This is if you go through the RERA Act. Now,
Oh,
along with that, there are certain things that we need to understand. During 2020 and till 2021, when the COVID regime was going on till some part of 2022 also, that time RERA came in with the clause of act of God. So now, until and unless there's a natural calamity which is outside the understanding of the human beings and cannot be, addressed by the humans at large, RERA gives you some kind of compensation on the delay that is caused. But that delay has to be reasonable in nature. It cannot be that 3 years, 6 months, and one day you are asking for the amount. Because generally court says कि इतना हमारे पास time नहीं है कि हम छोटे छोटे चीजों को देखें, because we need to understand the number of litigations against builders is very high. Every
Understood.
third or fourth day a new builder is being arrested.
Ji,
So
ji.
the amount of money and the compensation in place is there, and you generally get it back. But that compensation is based on reasonable apprehensions that what were the reasons that the delay took place? Were there any genuine reasons that took place? Not only for the delay, but also if the rates are increased by the builder, then also you can go to RERA and say that this is against the policy.
Understood. So it means that whatever contract you're making with your builder, as far as the PDC is concerned, as far as the rates are concerned, so if any deviation, you can approach RERA for that. Now, coming on to developer side, sir, what are the consequences for the developer who do not comply with, let's say, regulations of RERA?
Okay. So first of all, RERA compliance is bit like a corporate compliance. It's not like a normal government compliance. RERA works like a corporate society wherein there are a lot of compliances. Section 4 talks about the registration. So an individual who's selling you the house has to be RERA registered agent.
Understood.
Any random individual cannot sell a RERA property. So you have to be a RERA registered reseller or a contractor as per the act. You have to be a RERA registered developer to develop a property. Then there are certain compliances that every 6 months they have to give a report. Then if the builder does not comply with it, there are penalties that are put on him. But the side drop of that is the builders generally approach the NCLT and say that they have lost all the funds and they are, at the verge of collapsing and they have basically become bankrupt. So the better safeguard is rather than waiting for long, you should approach the RERA beforehand, because once the matter goes to NCLT, the scope of RERA vanishes. It diminishes to something like a very small amount that you'll be getting if you get it, because NCLT has got a bigger jurisdiction than RERA.
Understood.
So other than that, when we talk about the registrations of agents, for example, I as an individual want to sell a house or I want to sell a property, then I'll have to register in a section 4 of the act, which talks about the registration. Now, another thing is that even the builders give it in writing that this is the time period in which we will complete the project. If they don't complete the project, then the non-adherence to the timeline also asks them and causes them penalty. Now, other than the penalty, they also have to be giving the layouts to you. They have to give you the plan. They have to give you the schedule. They have to give you the tentative completion dates. So basically, nothing is in oral anymore. Now it
Understood.
has all come on to paper.
Understood. But I fathom how many are following that.
I would rather come to that, because see, you need to understand that any law that comes to the existence of the mankind takes some time to be a perfect law. We need to
Understood.
understand the CRPC and the IPC, that is the criminal laws in India, came long back in 1880s.
Ji.
And it's been more than 100 years plus now, and still certain laws are not being implemented to their core. But
Understood.
the earlier we were more like orphans. Buyers were like orphans who had no mom and dad to safeguard them. RERA
Ji.
has now come up as a guardian
Ji.
who would learn undertaking the care of their children in some point of time. It is not that as of now it's a perfect law.
Understood.
RERA cannot be a perfect law as of now, because it's in the very inception. It started in 2016. In 2026, it will complete its 10
It's in
years.
recent stages. Yes.
Yes.
Vinita Sahu, ma'am, you have some question at the end of the webinar. We will, open the forum for question and answer. That time you can ask the question, ma'am. You can lower your hand. So, Bali sir, आगे चलते हैं sir. What exactly is the procedure? How one can go about filing a complaint and seeking some remedy to the RERA? If somebody is facing some issues, list of issues which we've already discussed, starting from delayed possession to change in cost, some kind of fraud. So, how do we approach? What is the procedure, sir?
So basically, the procedure is developed into three parts. First is the conciliation. So before going to the RERA, one has to keep into mind that the communication has to be very clear.
जी,
Second safeguard that most of the buyers are not taking into place is that more of the service class people and people who are, in jobs and all, they generally have loans that are there. So they give a go ahead to the bank that whenever the builder asks, you release the amount.
जी,
So you should always keep it in mind that you should give it in writing to the bank that do not release the money without my written consent, so that you
understood.
know that at what stage, what amount the builder is asking for. Generally,
Okay,
what happens is the builders, when your loan is passed, he would say that release the whole amount to me right now.
okay,
Whereas the construction would be taking part in stages. So
yes,
you as a buyer should talk to the bank, give them in writing that whenever you're releasing certain amount to the you know
builder,
builders, it should be taken into my consideration and I should be taken into confidence that the amount is being released, and without my permission, the amount should not be released.
understood.
Second is after that, when you're writing the emails, always keep everything in writing. Generally, what happens is the buyers do well by communicating, but the only fault and the only mistake that they make is that the communication is all oral in nature. It
Oral,
is never in writing.
understood.
And court of law would not expect you to actually give your screenshots of a call that you made. They would actually be asking for communications that you made.
Correct.
Second is email is a good option, but it is always better to send them the copy of the email through a post also. That to a
Understood.
registered post, so that you have the receivings of the same and it all becomes evidence that you have tried your best to communicate with the builder and you're not getting a response to that.
जी,
Now, after that, the process of conciliation starts. Now, when you start the process of conciliation, what happens is that conciliation is a process in which both the parties sit down through a registered conciliator who talks to the parties and says, ki, bhai, what is the settlement that you want to come to?
जी,
Generally, conciliation is a step which is not utilized because it straight away goes to the tribunal. Now, when we talk about the tribunal, also, the tribunal is also divided into two parts. One is the first step, that is the RERA tribunal. One is the RERA appealant tribunal. So, what is the appealant tribunal? Appealant tribunal basically is where a decision is challenged either by the buyer or by the builder
understood.
after the first conciliation is done. Now, when we talk about the conciliation proceeding, it's a very simple process. You have to have your builder buyer agreement, the date promised to you. You need to hire a lawyer who's going to put in facts that this was the time that was given to us. This
Okay,
is the thing that is going on. This is the amount of delay. This is what was promised to us, slash, this is what has not been given to us. Therefore, this is the amount in compensation that is coming up. And we request the tribunal to give it to us because it's in our fair right to do it. And it has been obligated by the agreements that are in place. And we are not asking for anything that is not entitled to us.
understood.
So, generally, what happens is the filings of RERA are online. There is a big misconception that people come up, and generally lawyers tell ki we need to give 10 copies or 4 copies of the petitions to the court. Generally, after your case is registered and you get a registration number, after that you have to give 2 copies to the court. They have to be signed, and those signs should be always, you should know that whatever you're giving to the court, you should have gone well through it, because it should not be such that you've not crossed the 3 months, 3 years time, or 3.6 years time, or whatever time has been given by the
Correct.
bidder and still approaching the court, because it would become a useless litigation then, because it would come to no result at large. Now,
Understood.
once this starts, after that, first the acceptance stage comes in. Now, when the acceptance stage comes in the acceptance stage, you actually talk to the judge and tell him that, sir, this is my case. Your lawyer actually does it, or if you're going in person, you can also do it. But generally, it is advisable to go through a lawyer because it is not like the consumer forum. RERA is much different from the consumer forum because this act is more technical than the consumer forum. It
Understood.
it has got a lot of technicalities to it. So when you argue, your case gets accepted. After your case gets accepted, you move forward. And when you move forward, the argument stage comes in, pre-argument comes in, then the evidence comes in, the other party gives their reply, and then in the end, the judgment takes place. So this
So,
procedure
yeah, sorry, go ahead.
on and off takes around 1.5 years.
Correct. That is what I was coming to actually. So 1.5 year, you may get the remedy. What in case of the funds? Like, how does RERA regulate the use of funds collected from home buyers, which is which has not been used by developer, or if the money is stuck? In this case also, it may take the same amount of time because there would be multiple stakeholders to that complaint.
True. Now, to this, what happens is that 70% is the fixed amount. Generally, the buyer is not taking 70%, buyer is taking 100% from you.
Hmm.
So it is the buyer's cost comes out to be around 40-45% of the total project, of the total amount collected. Still, he is safeguarded with around 30-35%, which he is utilizing for escrows, and that is the amount that is going through. Now, further, the escrow account also has got an interest figure to it. There are certain amount of interest that the builder is getting on it, and whatever amount is there, the escrow amount has been made as a safeguard only. Not every individual approaches RERA. You need to understand that the rights and obligations of buyers are also not known to everyone because it is in the very nascent stage.
Correct.
So
Yes.
out of say 1,000 people, 10 people would approach the court, and those 10 people would get that amount. It is not that out the 10 people who got the amount will entitle all 1,000 people to get the amount. So what happens is the escrow amount itself is utilized for paying off the debts or the penalties that are coming up. So basically, it is your money which is paying you back.
Correct. You just said that, let's say if there are 100 affected, participant of that project, if only 10 approaches RERA, and let's say RERA gives the verdict in favor of them, so won't it be blanket sanction for remaining 90? Only 10 would get the benefits. That is what you mean to say?
So the basic answer to this is the Supreme Court has also said that sleeping courts cannot have the benefit. So until unless you do not approach the court or the
Okay.
forum, you will not be entitled to the benefits. Now, on this, I could also state that if you remember that there was a insurance on the cylinders that we have at our homes. So if
Yes.
the cylinder gets burst, there's a certain amount of money the government gives you. Now,
Mhm.
after the cylinder burst, not everyone goes to get that compensation. So those individuals who do not claim it will not get it.
Correct. 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 Well, most of them are not aware about it.
Mostly they are not. Yeah.
Yes, Chandan sir, Nitin sir, you have raised your hand. Let me request you once again that we will open this forum for question and answer and discussion at the end. In between the webinar, we may not allow it, sir. So unless and until you have some grievous point to make right now, which cannot hold till the end of the session, you can unmute yourself. Otherwise, lower your hand, sir. So I'll also take this time, ladies and gentlemen, to request all of you who are not part of our Telegram group, our WhatsApp group, and also YouTube channel. So please do follow, like, and share with your friends and family. Each day we are coming with a new topic of your interest, which benefit you and your friends in long term. So please do join our channels and do share about it. So coming back to the topic, Bali sir, now we have spoken about buyers as well as builders point of view. Now what is the role of RERA in addressing misleading information, misadvertising, or false advertising, incorrect promises? So how do we go about that? Because if you see, those are documented promises. So can one approach this authority or the forum for or against any misleadings happen?
Yes. So now basically the basic requirement for the RERA is that whatever brochure that you're giving to your buyer has to be submitted to the RERA authority.
Understood.
Whatever promises you're making, the copy is already with the RERA. So you cannot have any claims or any act or any promises which is beyond your sanctioned request. So basically, it is something like that you have been sanctioned certain amount of land, you have been sanctioned certain amount of houses, you have been given that this is your base rate and this is the maximum selling rate and at which you can sell. तो अगर
Understood.
आप उससे कम में बेचने की कोशिश करते हो तो ज्यादा में बेचने की कोशिश करते हो तो उसके अंदर भी हम रेरा जा सकते हैं. Rather than going to the authority, we can also write to the people who are the RERA adjudicators who are dealing with the sanctioning of the amount. So this sanctioning itself helps you to get away from the illegal and the misleading advertisements. Now, you must have seen there are a lot of advertisements where they say ki invest 20 lakhs and get 20,000 per month, or
Yes.
say
Yes.
invest 16 lakhs and get 18,000 per month. So
Yes.
now these questions are of double jurisdiction. When I say they are of double jurisdiction, it needs to come into consideration is that double jurisdiction means it would have certain role in the RERA. it would also have certain role in the consumer forum. So
Okay.
now, you being the litigator should take your call based on the funda that which place is going to give you a faster judicial proceeding and which is going to give you a better compensation to the same. Because as far as the compensation and the jurisdiction is concerned, RERA does not have any pecuniary jurisdiction as such.
Understood.
10,000 rupees per square feet place till 3 crores per house or 10 crores per house can also go to the RERA. But the only obligation is that it has to be RERA registered. Whereas consumer forum for the national forum should be not less than 2 crores.
Okay. Can you please explain, dwell more on this topic as far as cost is concerned?
What about the cost, sir? I am not able to
I mean,
understand the.
what you just said that you can go to consumer forum for 2 crores. So are you sealing the cost of the property in that case?
Yes. So basically, what happens is when we approach the consumer forum is divided into three parts. There's a
Hmm.
district consumer forum, there is a state consumer forum, and there's a national consumer forum.
Correct.
So generally, the jurisdiction or the peculiar jurisdiction is basically divided into the amount that is costing the value of the suit. So any suit which is at least 2 crores would go to the national forum.
Okay. Okay.
Lower than that would go to the state forum. Then that there is a T point of, I don't remember it correctly right now, it is 60 lakhs or 50 lakhs. If it is less than 50 lakhs, it would go to the district forum. So
Understood.
now, if you have to approach the NCDRC, as the Consumer Redressal Forum,
Mhm.
you would have to have a case suit of at least 2 crores, which means if your valuation of the house is 80 lakhs, you need at least three people or three buyers
Correct.
to approach the NCDRC.
Understood. Understood. Thank you for that, sir. Sir, any specific, you can say, provisions to protect the first-time buyer who's like, who's buying first time the property for the first time in his life?
I don't think so. There are any specific provisions for first time buyer or second time buyer or buyer enthusiast. So basically, that is the concept here because the law is simple. It never says that first time buyer is this or the second time buyer. There is no classification as such. So
Understood.
the classification or the definition clause is defining only, you know, a buyer. It is not defining the classification of the buyer, that what kind of a buyer it is, what is the times that he has bought the property, or is it for the first time he's buying or the second time he's buying. So the act defines buyer, investor, builder, project.
Oh,
That is the definition clause that talks about.
understood. Understood. Thank you, sir. The last thing I would like to know, and I would like you can, tell us for our viewers also who are at present available with us, as well as who will be watching the repeat telecast or recorded session on YouTube, how one can stay informed with the current happenings or any, modifications which happens in RERA. So how one can, be informed about it. Can you tell us about
So
this? That.
every state has got a RERA website.
Mhm.
So, for example, if you're in Haryana, so you will have a Haryana state RERA website, and if any project is being delisted, any builder is being delisted, or any builder who's registered with RERA, any notifications or notices that the RERA is issuing are always available on the state website. Other than the state website, there's a national RERA website. Now, the national website also has got most of the notifications that are coming in. So basically, when you ask that what is the site plan, are we being misguided about the site plans? So generally, certain site plans are also available on the state RERA websites. Now,
Understood.
the state RERA websites also have list of certain cases which are going on, which are under execution. So execution comes in, for example, a penalty has been levied on the builder, and the builder has not complied with the penalty, then you have to go for the execution of the petition. So after the execution is done, a government official is actually authorized to go and check the properties of the individuals who have defaulted in execution and then get that attachment done on your name. So this whole information is available on the government websites.
Okay.
Other
And
than
yeah, and as we've discussed that not all the builders or the projects are RERA compliant, is there any way we can find out about a particular builder also if we are thinking to invest into that? So do we need to
yes,
approach the builder, or can we see that information on some platform like, the government websites?
so government websites have the list of RERA registered builders, RERA notified projects. Other than that, you should always ask your builder about the RERA number.
Okay.
So there is a registration number that every builder and the agent has. So even if an agent is selling you the property, you ask him what is your RERA number, so that that authorization number is with you. Then you can actually search from the database whether that individual is genuine or not.
Understood, sir. Thank you, Govind sir. I'm done with all my questions.
You gotta focus on yourself, on your faith, on your dreams, on your mind, on your health, yeah.